what I was, why don't we do this unless anyone has any other ideas? Let me talk for a little while, and people can feel free to interrupt and ask questions if you want to take it a different direction or ask any questions. But what I was going to start out with was the way I've seen in my thinking over the years the benefits of the praxeological approach. And praxeology was Mises's term for the logic of action. And so he used that as the foundation of his economic theorizing. So he basically tried to look at what the consequences were in sort of a pure theory of human action. And so he derives from this the basic categories, sort of in a Kantian sense of means and ends, opportunity cost, things like this, and also some elementary notions of economics, like the idea that if you increase the supply of money, everything being equal, then prices will go down or be inflated. If you increase the minimum wage, or if you impose a minimum wage on an economy, then everything being equal, it would cause unemployment. So you can deduce certain things like this. So that's the economic side. In my thinking, when you think about libertarian property rights rules and Lockean homesteading and things like this, if you think of human action as being a human being is an actor who is not merely a deterministic behavior, right, but someone who has purpose and choices. Some human actor who looks at the world and envisions a certain future, and he's basically uneasy with it, or he thinks he doesn't want what he predicts will come about to come about. And he imagines that he can interfere with the course of events and make it be different in a way that will please him more. So that's sort of the basic framework of human action. So what he does is he employs his knowledge of causal laws, that is physics, basically, to decide what means are available, that's scarce means in Mises's term, that he can use to change the course of events to achieve the ends he wants. So you can see that the two ingredients of successful action would be, number one, having available means available to you that you can use to causally change what otherwise would happen. So that means the means you employ have to actually work. So if you try to make a magic spell to make something happen, it's not actually going to work. Or if you do a rain dance to make it rain, it actually won't work. It's not a good means, although you may believe it's so. And you also have to have knowledge. So if you're ignorant of the ability of gunpowder to explode, then you wouldn't use it to make a gun. So you need the combination or the intersection of knowledge and the availability and control of scarce means. Now, in the libertarian sense, the reason we believe in property rights is because the scarce means that are necessary ingredients of action can only be used by one person for a given purpose. That's what scarcity means. And this is the purpose of property rights, is to allocate one owner to a given contestable resource. But you can see that this doesn't apply to knowledge, which is one reason why intellectual property law makes no sense and is confused, a confused notion. So, for example, any number of people can use the same idea or knowledge at the same time, like how to make a fire, or how to build a hut, or how to sing a song, or how to cook a certain food dish, or a technique for catching fish, or for planting food, etc. But each of them can only use these scarce resources or means one at a time. So the property rights are only for the scarce means or resources. So the Lockean idea, which is basically the libertarian idea, says that whenever we identify a scarce resource in reality, that is any possible means that could cause a given result to occur, something that people can clash over or conflict over, when we have such a resource, then civilized people want to say, instead of fighting over this physically, when we have multiple claimants for this resource, we're going to try to solve this in a peaceful, civilized manner. So we're going to try to determine who's got the better claim to this resource and give them some property right in it. And they're going to be the winner. They're going to be the one who gets to use this thing. And then they can use it peacefully and productively, and everyone else knows that it's theirs. And in this way, we have a free market and capitalism and trade, the division of labor, etc. So the Lockean answer is when there are more than two or more people that possibly could contest a given scarce resource, that is a scarce means, that's a means of human action, then whoever either homesteaded it first, that is, had the first use of it, or who acquired it by contract from a previous owner is the one who has the better claim to it. So, for example, if I am the first one who acquires a resource, like a piece of land or some iron ore from the ground, then I have a better claim than someone who came later, unless I gave it to them by contract. So normally between two people, the one who has the earlier claim to the resource has a better title to it. But that can be defeated by certain exceptions. Number one, as I mentioned, would be contract. So even if I had it first, if I contractually transferred it to you by gift or by some kind of a sale, then the person I gave it to now has a better claim than me. Not because he acquired it first, but because I gave it to him. Okay? And another exception would be if I committed some kind of tort or offense or crime against him. So let's say I injure him by invading his property or his body so that I owe him some kind of restitutionary payment. Well, now he's got a better claim to my property because I did something to him that gives him a claim to it. But unless you can find an exception, like a contractual bequest or transfer or some kind of crime or tort, then the guy with the earlier usage right or claim to it, and ultimately going back to the first homesteader, gets it. Now the reason for this is because unless you could have a better claim than latecomers, no one could ever use things in the first place. We would all be living in a world of unowned resources and no one could use anything. You have to have the right to take things out of the state of nature, out of their unowned state, and start employing them, because if no one could do that, then we wouldn't even be able to live and survive. So there has to be the right to take things out of the state of nature, which means that it basically shows that the earlier claim has to be superior to the later claim. Because if it wasn't superior, then it means you have the right to be the first one to use something, but then someone else could come along and take it away from you right away, which means we're back to violent clashing and conflict and we don't have any property rights system. So that's sort of the basic framework of the libertarian property rights paradigm, and I think it's implied by the praxeological view of human action. And you can also see that it rules out intellectual property as a type of property, and it implies what other types of things can be property. The question is not what is property. The question is who owns this resource. That's always the question. So I find it helpful not to use the word property to refer to things that we own, because then you have a confusion in the discussion. People say, well, what's property? That's never the question. The question is always, when we see a scarce resource that people can potentially conflict or clash or fight over, who owns it? That's always the question. Who has a property right in it? Not what is property, but who owns this particular scarce resource? And when you focus on the question that way, then the entire question of intellectual property and rights in intangible or non-scarce things really never arises, or it becomes clear when someone suggests that what's wrong with that notion. And it also focuses you on, well, among peaceful, cooperative people, when they're focusing on who between multiple claimants to a given resource, who has the better claim to it, then the natural rule would be the one who had it first. I mean, even dogs recognize this, right? If one dog is munching at a bowl of food and another dog approaches, the first dog is going to growl and warn him to stay away. So there's a naturalness to the first come, first serve idea that's at the heart of the Lockean and libertarian idea of homesteading. I can take this in other directions, but if anyone has any questions or comments right now, I'd be happy to address some questions.
Yeah, Eric Vaden has a question here.
In Locke's book, he mentions you have the right to your property, but you can't let it spoil. So let's say, for instance, I have like a vast land and I can't really take care of all of it. Do I lose the right to some of it? Just because it spoils?
I think so. So my view is that the basic Lockean idea is libertarian, but a lot of Locke's reasoning he gives are not necessarily libertarian. So, for example, Locke starts out with the idea that God owns the universe, and there's a God, and God grants it to humanity in sort of this commons. And because he grants us this, and he grants us self-ownership rights. So I don't think you really need to start with that to be a Lockean. You just need to go with the basic logic of what he's saying. And then he also has this idea that there's a part of Locke which is the proviso, which gets a little bit at what you're suggesting. So Locke said you could homestead unowned property as long as you leave enough and is good for other people. That's called the proviso. And the more strict, anarcho-Austrian libertarians like Hoppe and people like Anthony Diasse and me would reject that. I don't think that that's actually a condition on acquiring property. The reason is for someone to object to your acquiring an unowned resource, they would have to assert an ownership claim in that resource in the first place, which means it wasn't unowned at all. So basically, if you assume that it's unowned, no one has the right to object to your acquiring it, whether there's enough and is good left over for anyone else or not. So there's sort of, you have to pick your sides. Now, there's a mutualist argument, which sounds a little bit like what you're getting at, which is the idea that if you don't continually use your property, then other people can, say, squat on it, etc. Now, I don't agree with that. I don't think that's compatible with the strict Austrian libertarian perspective on Lockeanism. However, as a practical matter, there's something to it in the sense that, let's say you homestead a huge tract that is, look, it's not easy to control property. You have a sort of responsibility to keep it up, to use it. And if you have a huge tract of land that you've acquired somehow, unless you have a lot of resources and you're using the land productively, it's going to be difficult for you to monitor it and police it all the time and make sure that 5 miles away in some little remote corner of your land, there's not someone squatting on it. And if you don't do that, then over time, then the community is going to recognize that you've basically abandoned your claim to it by failing to object to people's use of it. So I think there's a natural limit to how much property or how many resources you can acquire by your physical use, unless you're actually using it productively, which is why Rothbard talks about what he calls the relevant technological unit, or RTU, in his air pollution piece. So he talks about how in a given community there's a certain way of using a resource by human beings, and everyone recognizes that, and that sort of defines the nature and the boundaries of the property rights that you acquire when you use something and when you mix your labor with it.
Okay. Thank you. I had one more question. It's somewhat similar. I think I heard it online once. In the case of if you own a house and your neighbor owns the house next door, you have allowed your grass to get so long that it's bringing a lot of snakes, and your snake bites the neighbor's dog and he dies as a result of it. Are you somehow liable?
I haven't heard that particular example before. I think so the basic question here would be whether and to what extent you're responsible for your property. Now, strictly speaking, in my view, the libertarian idea is an idea of what you have a right to, not what you have responsibility for. You have responsibility for your actions, right? In other words, you have an obligation, a negative obligation, not to invade the borders of other people.
Yeah.
So when people say, if you own a piece of property, you're responsible for it, they're thinking of something called strict liability, in a sense, or they're thinking of the idea that responsibility is coupled with ownership rights. But I think that's not really a very rigorous way of thinking about it, because if you really believe that, then let's say you own a gun or a knife, and some bad guy steals your knife from you, and then he uses the knife to hurt someone. Now, under the law, you technically still own the knife. So if you're responsible for whatever's done with your property, then you'd be responsible for the crime this third party committed, which I don't think is correct. So I don't think you can say as a blanket matter you're responsible for what happens from your property. You're only responsible for your actions. So the question would be, do you have a duty with your neighbors to keep your grass mowed, to not let snakes infest your lawn, etc.? And I think that'd be a blend of inter-neighbor contracts, which is sometimes called restrictive covenants, maybe implicit, maybe explicit. And it would also be a blend of the idea of the attractive nuisance or just the nuisance idea. In other words, are you using your property in a way that interferes with your neighbor's property? Now, the answer to the question I can't say from my armchair. I would think that if you are violating, community standards of how reasonable people use their property, and your neighbors are complaining that snakes are coming out of your property onto ours, and you need to either cut your grass down or let us do it for you, and you refuse to let them do it, then probably an argument could be made that you're causally responsible by your actions, right?
Yeah.
For
Or
the
lack of.
snakes, or your inaction when well, your action would be denying permission for others to put a fence up around your property or to mow your grass on their own. So I think it'd be something like that. I think basically you'd have people, they would go to court and they would try to settle these disputes in a reasonable way. And how juries or judges would decide these things in such edge cases is hard to say. But I think basically you could make a case that it was a type of negligence, a type of abuse of your property rights.
Okay. All right. Well, one more, because you got me thinking about it. When you're talking about, so libertarianism is involves negative rights, and I have the right to not be attacked by another person. So hopefully it doesn't sound too similar to the last one, but let's say, if you believe in like the Tannehill and Rothbard restitution system, if someone's dog attacks me, do I have the right to restitution from them? Since obviously the dog can't grant me that.
Yeah, that's a difficult one. I mean, honestly, I haven't worked out in my mind what I think about strict liability and responsibility for property. Like I said, in the knife case, the knife is an inanimate object. So unless you were somehow complicit or even negligent in someone stealing your weapon, I don't think you're responsible for that. I think the basic libertarian idea is that you're responsible for your actions. So the question would be, by having a dog, which is an animate object that you own, and by being the only one that has the legal right in the community to control the dog, in other words, no one else has the right to put a leash on your dog because you own it, then does that imply some kind of responsibility to be responsible in the exercise of those rights? And I think you could argue that it does, because it's an implication of the idea that you can perform any action that you want except invading the borders of other people. And remember, all actions involve the employment of scarce means, which means your property right, things that you have a property right in, which would include your animals. So you could say that because you have the legally recognized right to control the dog, and because no one else does, they can't restrain the dog, then basically the dog is an agent of your will, right, and is going out and doing something that you are responsible for, because it's like a proxy actor for you. Just
Yeah.
like if you had an employee and you said, listen, I've got a successful company, let's say we're drilling oil wells, and you use your profits and you hire employees, and you tell one of them to go over to this unowned area in Texas and homestead a well for you. Well, he's homesteading it on your behalf, so you would be the owner of the well, not him, even though it was his action or labor involved, because he's your agent and because of the contract between you. So I think by some kind of analogy, you could say that your animals, at least in some cases, are performing actions on your behalf. So I would think you would owe restitution, at least in some cases.
Okay. Thank you. Another question here.
Hello, this is Joshua Stevens.
Hey, Joshua.
Hi there. Okay, so I had two brief questions. All right, I know that you and Robert Wenzel are supposed to be debating IP issues, and I've heard him mention that Dr. Rothbard, while he for the most part didn't support IP rights, he did support, I guess, copyrights. Could you elaborate on that?
He didn't support copyright. He supported, he was against state legislated patent and copyright schemes. But what he said was that in a free market, if you owned a product, you could have a contract with your buyer. So you sell something to a buyer, and you could limit what they purchase from you. So instead of selling them a mousetrap, let's say, you could only sell them basically a partial right to the mousetrap, like the right to use it for personal uses, and you would retain other rights, like the right to copy it. Which actually doesn't make a lot of sense. I think he was confused on this, but I think what he was getting at was you could have a contract with your buyer, and you could say the buyer agrees contractually either that he's a co-owner of the mousetrap and he doesn't completely buy it, and so that the seller still basically owns it and is only lending it or leasing it or giving partial rights to the buyer, so that if the buyer uses it in prohibited ways, he's committing a type of trespass. Which is a imaginable relationship, although it's not practically feasible. Or he's imagining a contract where the buyer buys the mousetrap but agrees that if he makes a copy of it, let's say, or if he learns anything from the mousetrap and makes an improved mousetrap on his own, then he agrees to pay some kind of damage payment to the seller, which is also feasible but impractical for a couple of reasons. Number one, it's so hard to monitor these things, and a seller of an iPhone or a mousetrap or a book, they just want to get their money and be done with it. They don't have to monitor the activities of millions of people who are buying $10 or $100 items, and nor do the buyers want to be monitored, and nor do the buyers who pay a small fee for a useful item want to be limited in what they can do with it. If I buy a book from someone for $20, and the seller says, I'm only going to sell you this book on the condition that you agree to pay me $1 million if you make a copy of it, or if you learn from it, or it influences one of your novels in the future, or if you loan it to a friend. Most people would say, I'm not going to take that risk on. It's not worth it to me to get a $20 novel. I'll just go pirate it, or make a photocopy for my friend, or I'll go buy a book from a more reasonable seller. And even if the seller was able to persuade a few dupes to enter into such a contract, it would only affect that small number of stupid customers who enter into these contracts. It would not affect third parties. What Rothbard said was that if you sell the mousetrap and you stamp copyright on it, then it's understood by the buyer that he's only getting the right to use it for certain purposes, but not the right to copy it. And therefore, under this sort of bundle of rights idea, the buyer doesn't own the entire mousetrap. So if he sells the mousetrap to his friend, then his friend can only get the rights that the buyer had in it, which doesn't include the right to copy. So that's Rothbard's argument. The problem with it is that it sort of begs the question of whether there's intellectual property at all, because it assumes that there's property rights in knowledge, because it assumes that this third party needs the right to use the knowledge to make a copy of the mousetrap. In fact, he doesn't even need to buy the mousetrap or even need to use or touch the mousetrap to learn about it. He could observe it from afar, or he could learn from it from someone else, or just have its operation described to him by the buyer or someone else. And so now he's in possession of knowledge, but he never entered into a contract with the buyer or the seller. So he could not be possibly bound by contract, and under the first theory I mentioned, he wouldn't be guilty of trespassing either, because he is not actually using the mousetrap. So under neither theory, which Rothbard doesn't really lay out explicitly, I'm just giving him the benefit of the doubt. I'm saying that's the only two possible theories he could use, is that the buyer's misuse of the mousetrap would be a type of trespass, or it would be a violation of contract. Whichever one it is, the third party is not guilty of either one, because he's just using knowledge. And he could, of course, spread that knowledge to other people, and then eventually everyone in the world knows about it. And not only that, to sell the mousetrap in the first place, the seller is promoting its benefits and its features. I mean, he's trying to say, my mousetrap is better than the old generation mousetraps. It's got these new improved features. He's advertising, he's telling the whole world, he's preaching it from the rooftops. He's already telling everybody what's innovative about this new mousetrap. So, he can't expect people not to learn from that action. It's got really nothing to do with the buyer. So the basic problem with this Rothbardian idea, and by the way, it contradicts Rothbard's views on defamation law, which is another type of intellectual property, which is in Ethics of Liberty, where he says that the problem with reputation rights, which is what defamation law protects, is that it presupposes that you have a right to your reputation, which is what other people think about you. And he says, well, it's obviously absurd for one person to have a property right in what other people think about him, because you don't own their brains, basically. So similar reasoning would shoot down the IP idea, I think, because you don't have the right to what knowledge other people have in their heads and what they use to guide their actions. This is why I started out with praxeology, because I think it helps to clarify this. It shows that you have property rights in scarce means, things that you can clash over, but you cannot have property rights in knowledge. Everyone's free to use the same knowledge as long as they acquired it. Well, no matter how they acquired it, to be honest. Whatever information people have is going to guide their actions. They're going to have to consult it when they decide what actions to pursue and what means to employ to achieve their goals.
Okay, and one last brief question for me. All right, so I understand that, like Dr. Hans Hoppe, he mentions that he promotes decentralization as a way to end the state. And so I understand that in regards to like immigration, he says, well, look, the taxpayers essentially, the roads are essentially, their property, public property, essentially their property because their private property, which is tax dollars, goes to fund and pay for. So if let's say in some city like, I don't know, Miami, if voters say, look, we want to crack down, on immigration or whatever the case may be, let's do that. But then I understand that Dr. Walter Block says, okay, it doesn't matter. Roads are essentially open to the public. You can't have, you try to initiate, private property rights over that. What is your take on that between, let's say roads and immigration?
So I think, well, first of all, Hoppe and Bloch and me are all anarchist Austrian libertarians, and so our ideal goal would be a totally private property society where there is no state in the first place. So there would be no such thing as immigration. It would make no sense. There would only be private property owners, and you could never enter someone's property without an invitation, and would just be, totally the domain of private law. There would be no such thing as national borders, etc. What Hoppe is trying to point out is that in a second best or even third best sort of situation, what he's trying to point out is that the assumption everyone has that even among radical libertarians, like Rothbard, for example, there's sort of a background assumption that even though our modern liberal democracy system is not ideal, it was an improvement over what we had before, which was monarchs and kings. So what Hoppe tries to argue is that, number one, the move from monarchy to democracy after World War I was not really completely progress, that there were negative things about it, that in some ways monarchy is even better or less bad than democracy, although he explicitly rejects monarchy and democracy because he's an anarchist. But what he's trying to point out is he's trying to say that if you had to choose a less bad government, in many ways a monarchy would be better, and the reason is because the monarch has better incentives to more intelligently or efficiently run the country than a democracy does. And this is just, in a way, standard public choice, type theory. Your elected representatives have an incentive to waste, etc. Whereas a monarch who had a property right in sort of the base of the country and could turn it over to his heirs has sort of an incentive for quality control, etc. It doesn't mean it's ideal or utopian. So he's kind of coming up with this monarchy versus democracy idea to criticize democracy, not to promote monarchy. And what he points out is that the immigration policy of a monarch would be different than that of democracy for various reasons. Okay, the rulers of a democratic society have an immigration policy designed to maximize their votes. So the Democrats might want more, minorities to come in because they're going to vote Democratic, etc. Whereas a monarch would be more concerned with some kind of quality control, quality of life issues. So he would maybe let migrant workers in for a while, but then keep them out because they're not part of the kind of country. he's not necessarily supporting this. He's just kind of contrasting it to show that we shouldn't just assume that whatever the policy is in a democracy is compatible with or getting close to an approximation of a libertarian society.